welcome back to the Data Privacy Party install. I'm your host, Hunter Sunbeck. Today, as always, this is the party where we talk about privacy regulation, privacy technology. Hope you learned something new today. The goal of this party is to bring information to folks, information to those that can hopefully use it to kind of take a better approach towards protecting their own privacy, whether you're an individual or an organization dealing with personal information. This podcast hopes to be able to bring you some action items, some areas where you can actually take control of the information that you're using. So remember to check us out at dataprivacyparty.com for some of the content we have around regulations and some other thoughts. We are on Spotify, YouTube, Apple Podcasts, and you can find us at dataprivacyparty.com as well. Want to apologize to all of my regular listeners, however many there are of y'all out there. It's been a busy last few months, especially in May. So I actually haven't had a chance to record during that time. So negative, y'all didn't get any content that week, but on the positive side, you should get 2 episodes in June, barring plans don't change between now and the end of June at this point. So that should be exciting for those of y'all that appreciate the content. One more thing I'll add in as to why May was so busy is that I was really studying hard, getting ready for the CIPT certification. That is the International Association of Privacy Professionals, IAPP's certified information privacy technologist. So that's kind of why there's been kind of radio silence on my part. So I apologize for those of y'all that are regular listeners of the pod. But now that that exam is behind me and out of the way, we can kind of move on and do some more fun stuff. So here we go. What we've been doing and going through lately is just kind of a learning series based on the introduction of privacy, a textbook that I use in order to help me study for the CIPT. We've gone through a few modules over the last several months for those of y'all that have been tuning in. So we talked about introduction to privacy, we talked about engineering and privacy, encryption and related technologies. So the next one that'll come up, we'll talk a little bit about identity and anonymity and some of the ways you can act to kind of protect some of those areas and enforce or implement anonymity into not just your regular life, but if you work for an organization within their privacy compliance area and you're trying to think about how we can kind of create policies, enforce technology around some of those areas, then that's definitely one you'll want to listen to. For those that listened back to the very first episode of 2023, we were planning on doing the series, and then come June, we would actually do kind of a midway recap of 2023 about what's been going on. And that's where we are today. So identity and anonymity will come out next, should be in a week or 2 is my plan right now. We'll kind of see what ends up happening between now and the end of May. But today, we're just going to talk about what's been going on in 2023. Some of the information will be stuff that you've probably heard in past episodes because we kind of keep up with the latest news in there. But this is primarily centered around some of the biggest areas. So we're covering state privacy law updates. There's a newly published Privacy at a Glance report I would like to kind of talk through. This is kind of focuses on global privacy and consumers' thoughts about that from the IAPP. Some other legal updates around privacy fines and so forth, especially one big one to kind of tease what we're going to be talking about lately. This is a product that most folks probably use, and it's just kind of continued to grow its tentacles, I guess, through in different areas with the European Data Protection Board and the DPC. And that relationship just continuing to blossom. I'm sure that most of those folks that are part of it are very happy with that. And, lastly, just some predictions for the year of 2023. And so that'll be centered around the legal landscape, just kind of my thoughts on it. Reminder, I'm not a practicing attorney or lawyer, but I'm just a privacy enthusiast, a privacy professional that primarily operates right now, at least in the world of privacy technology and privacy and security areas. That could change one day, but for right now, we're very much more on the privacy side of technology, not necessarily the legal side. All right, so as we get into state privacy law updates, let's cover each of those states that have introduced new laws. I'll kind of briefly talk about each one. I'm not really going to go into too many details about them. Folks can do that kind of on their own time. This is just a very high level of each area. And, a lot of these we're starting to see kind of start to look the same. A lot of them base their frameworks off of some other ones. There's the funny Spider-Man graphic, reminds me of each one of them kind of looking the exact same, but just maybe slightly different in more ways than just the state that it's, the state that it's bringing in. But we'll start with Iowa. So this was pretty recent, about a month or so ago, maybe a little longer. I can't remember off the top of my head. There's just been so much activity lately, it's almost hard to keep up. Bill SF 262 was passed by the Iowa legislatures. This bill takes effect January 1st, 2025. I guess call it a law, not a bill anymore since it's gone through. But this provides some basic concepts of access. So consumers have the right to access their data. They have the right to delete their data upon request. They have the right to data portability. And they also have the right to opt out of sales of their personal information. These themes are going to be seen in a lot of different bills that have recently come through. For those of y'all that also aren't familiar with data portability, you can download your data from an organization and then take that somewhere else. So Facebook offers that kind of service. If you're on your phone, you go and navigate through your settings and you can find that area right there. This law for Iowa also requires privacy notice and transparency to consumers. So the organization that is collecting information on Iowa residents doing business in Iowa has to provide a notice explaining collection practices, processing practices, if the data is being shared with third parties, kind of what's going on there. Surprisingly, and this is, I think, the only state recently that has this going for them right now, there is no risk assessment that is needed. So, which is pretty interesting. We don't really see that in too many laws. And basically what I mean by risk assessment, for those of y'all that are not as familiar, it's a risk to the processing, collection, practices of the organization. So a lot of these other states we're about to mention all require a risk assessment to be performed. Utah is the only state, ever since California passed the CPRA, Prop 24, Utah is the only other state that doesn't require this sort of risk assessment. It also doesn't require, per limitation in processing, but that's a different story. This risk assessment is just assessing the risks around collection, processing, storage practices for personal information of consumers. So like any standard risk assessment, just a very focused process area. Next state we want to look at is Indiana. So you're going to see a lot of the similarities in each of these states, and I'll try to run through them as quickly and effectively as possible. But Senate Bill 5 comes into effect January 1st, 2026. This was passed. This provides a few more consumer rights than Iowa does. So consumers have the right to access, correct, delete their personal information, and then portability, opt out of sales of information as well, just like Iowa. They require privacy notice as well as a risk assessment to be done annually and provided to the Attorney General upon request. It's also worth noting each of these states does not allow for private right of action. For those of y'all that aren't familiar with what that term means, that is essentially an individual, myself, can take legal action against an organization. Every sort of enforcement of the law as it stands today will require me, you, any other consumer to submit complaints to the Attorney General. and then they have to decide whether they need to take action or not against an organization. It doesn't allow a private citizen to take legal action against an organization. And so that's going to be the case with all these that we talk about. So for those of you that are practicing attorneys thinking you can do it on your own, unfortunately, you'll need to bring that to the Attorney General. You won't be able to actually do it on your own. Next one is Texas. So this one actually, to date, as of this recording, has not been signed by Governor Abbott, but it has gone through both chambers, been passed. This is the same as Indiana: access, correct, delete, portability, opt out of sales, risk assessment as well, privacy notice, purpose and process limitation. So I'm not going to go into too many details around what makes these all these laws different. This is just for you consumers to know, and then you can take a look at it whenever you have free time, whenever you decide that you really want to dig into some of these government privacy laws, legal privacy law text, which I can imagine there's probably only a very small few that actually enjoy doing that. Myself is one of them, actually, whenever I get the free time to do so. But nonetheless, we'll keep moving on. The state of Montana is also the latest one. So Senate Bill 384 comes into effect October 1st, 2024. This same exact thing as Texas, Indiana: access, correction, deletion, portability, opt out of sales, and privacy notice, risk assessment, purpose and process limitation. We'll jump down to Tennessee. Same deal as Montana: access, correction, deletion, privacy notice, risk assessment, purpose limitation. This one, the difference goes into effect July 1st, 2024. And for those of you that want to look up the legal text, this is House Bill 1181. The next two states that are kind of on deck at the moment, we've seen stranger things happen in the past, but Delaware and New Hampshire both have bills that are currently in cross committee. These are going to hopefully go through. We'll kind of see what ends up developing over the course of time. Some others that I did not, go into too much detail on, but did mention Nevada and Washington both passed kind of state level healthcare data acts. If you can just imagine kind of a merging of consumer privacy law with HIPAA at this, and then think about it at the state level. That, for the most part, is what you're going to get with each of those bills. I'm still kind of working my way through them, trying to publish some pieces about some need to knows for consumers. So to kind of conclude on all these updates, a lot of these bills are starting to look alike. Like I mentioned, the Spider-Man meme, that kind of makes me laugh a little bit. Each one of them looks alike, with access, correction, deletion, opt out of sales, and data portability being common themes to allow rights to those consumers. And so kind of the three main areas. Actually, I had kind of a privilege of sitting in on a presentation a few nights ago that a lot of bills are kind of focusing on, and we can kind of see this at state level, at least in the United States. I'm not going to necessarily speak for other countries, but they prioritize the rights of individuals. They provide transparency. They prioritize providing transparency of processing and collection and storage practices. And they also require the implementation of security measures to reduce the risks to the collection, processing, and storage of personal information. So that's essentially your state level privacy law recap. And hopefully you guys learned something. Feel free to look up those bills on your own time. It's rather interesting to see. A lot of them are the same, but then there's some threshold requirements around revenue, processing of personal data. Some of that stuff is a little bit different. I know Montana, for instance, has a smaller total population of consumer data processed, but that was primarily done to coincide with the population of Montana. So it would have been a greater percentage if they would have done 100,000 to the population of Montana than 50,000, I think is the numbers for those, while as other states do 100,000. And they did that just so it's a percentage based rather than a raw number based type of thing. So next thing I mentioned earlier, I wanted to kind of touch on the IAPT's Privacy at a Glance report. So this report was done fairly recently. It came out This is going to kind of cover global privacy preferences, I guess you can put it, knowledge preferences. It was done by a principal researcher of IPP on kind of privacy and law policy. So I'm not going to go through the whole thing, but I just want to read on some top areas. So concern about online privacy. Generally, a very high percentage of folks are concerned. So 27% listed that they were very concerned, while 41% said that they were somewhat concerned. If you're good at math, that's a 68% bucket, if you will, in the concern category. I think if we would have done this several years ago, that would not be as high. But now that I think content, much like this podcast, is more widely available, so folks actually kind of understand a little bit more about what is important to them privacy wise, what are the legal ramifications around certain things. I mean, GDPR is just a great privacy law to get people in the know about what's going on and what rights they have. I mean, that law allows private citizens to take other private citizens to court. I mean, there's usually 500 euro fine, like very small 1,000 euro fine, very small fines related to what happens. But we see individuals taking each other and companies even to court and, getting a lot of rulings for, the privacy violations as stated in GDPR and what constitutes that stuff. So people are generally more concerned about their privacy, especially online. The biggest factors motivating companies to take steps towards privacy. This was interesting, and this will tie into another statistic I'll talk about in a second. But 35% of respondents, and keep in mind these are all consumer respondents, you and I, 35% responded that the companies are motivated to take steps towards privacy to comply with legal obligations. It makes a lot of sense. That's usually why companies do what they do. I mean, companies would not get financial audits done if the SEC didn't require that, if those trading on the New York Stock Exchange didn't have that be a requirement. It's just extra. You're paying to avoid larger penalties later on, and most companies are on board with that. But regarding finances, I think it's very difficult to convince companies, especially here in America, when there aren't very many privacy laws. It's very much state level. It's not federal level like GDPR applies, but it's difficult to get companies on board taking privacy seriously. At least, right now. This will change in a year, 2 years, 3 years from now as more privacy content and regulations and standards all get built out. Surprisingly, only 10% of respondents say that the motivations behind companies taking steps towards privacy is to align with their corporate values. That tells me people don't think corporate values include protecting the personal information of their customers and consumers. Not to, if you ask me, I'm not too surprised that a lot of corporate values don't involve protecting the personal information of a lot of consumers. This could change in a year, 2 years, 3 years, 5 years from now, but it's just very interesting that the motivation around, and I think this kind of maybe says who we are as a society. The biggest motivator is around avoiding legal, fines and complying with legal obligations. Yet only a small 10%, granted larger than maybe some of the other motivators people listed, but this was the lowest of all those that were named until you got into the other category. 10% said that it's to align with corporate values. So that tells me there aren't very many companies out there with corporate values that include the protection of personal information, which is kind of sad. In my opinion, I mean, obviously I'm biased speaking on behalf of privacy professionals. We would like that number to be much higher, but that's the case as it is in 2023. Another stat, so this kind of ties into what we just talked about. So people how many people or what percentage would you say is that you'd stop doing business with an organization once they're involved in data breach? Those of you listening, go ahead and shout out a number if you think about what percentage that might be. The answer is 80%. Stop doing business if they found out their information is involved in data breach. I'll be honest, I thought that number is a little bit low. I'm sorry, I thought that number was a little bit high. Just because the kind of way that some organizations have made it difficult to switch from one to the next. Some are easier, some are harder than others. It just kind of depends on what subscription model, what tier you get, what kind of stupid contract you get yourself accidentally locked into whenever you apply for, I don't know, loan, grant, whatever the service you're looking for. But this kind of ties into that 10% number regarding the main motivations behind corporations taking steps to protecting privacy. So people don't think orgs care about their privacy, so they're often more inclined to just switch products as soon as something goes wrong. That's kind of what that number tells me. 80%, fairly high. So there's 20% of people that wouldn't, but 80% would stop doing business and take their stuff somewhere else. Now, granted, you're probably gonna get the same result of a company that doesn't care about their corporate values, but they're more inclined to put compliance obligations ahead of that stuff. But that's just the world we live in right now. Things will change as time goes on. But the last stat I wanted to share from that report is that 57% think AI poses a significant risk to privacy. More than half. Not too surprised by this number, but it's just interesting with a lot of the different AI talk going on out there. I mean, I think some folks may either are too informed or maybe not as informed about what's going on, or have too much of a head in the clouds sort of idea of what artificial intelligence might be. We'll kind of talk a little bit more about that later on, but just wanted to share that stat with you guys because I just thought it was interesting. Over half of the world thinks AI poses a significant risk to privacy, which most of the time it takes a little while for people to think about that with emerging technologies. But I think with a lot of news coverage that's centered around this topic has got people really thinking a lot more about what information is out there, what information might an AI have access to, and what might that AI do with that information when it comes in contact with it. Next part, I want to talk a little bit about privacy fines and other legal updates. So there's been quite a bit of activity by the FTC in the month of May. We'll get to that soon. I want to spend most of the time covering what's going on with Meta. Those of y'all that have been living under a rock lately, let me inform you of what's been going on. So on May 12th, about roughly a month ago or so, a decision was kind of handed down by the Irish Data Protection Agency to hit Meta Platforms with a 1.2 billion euro fine. This is actually the highest fine ever issued by the highest on behalf of or because of a violation with the General Data Protection Regulation, GDPR. The former largest fine was Amazon at 746 million euros. But let's get even more, even more interesting. Meta actually accounts for four of the five largest GDPR fines, and 5 of the top 8 if you include a Facebook subsidiary of Meta, because Meta Ireland is kind of the main organizational body, if you will, but they also have Facebook subsidiaries. So if you include that one in there, that would be 5 of the top 8. So that actually ends up totaling almost 2.5 billion euros, which by far there's not hardly many organizations that can recover from fines like that just in the past 2 years. And it's just insane a company like Meta is unable to implement privacy protections over data. A lot of these because they transfer data from Europe to the United States. And so those of y'all that have been around a while remember Schrems 2 invalidated the Privacy Shield, which was originally in place to ensure data transferred from the EU to the US has appropriate measures in place. You get Privacy Shield certified, your organization is free to transfer data as it needs. But that was invalidated. Because it was invalidated, organizations now can't transfer without really looking at some standard contractual clauses as well as other privacy protections organizations in the US have in place. Because the way the court recognizes it, the US just doesn't have the same legal structure as the European Union. So there's not legal protections in place around European citizens' information once it gets to the US, not afforded the same rights and privileges as they are with GDPR. So when companies do this, obviously it warrants some fines and investigations. So this is just what happens. So it's an insufficient basis for legal processing was kind of the general term issued. So they found violation of Article 46 of GDPR by continuing to transfer personal data to the US after the Schrems 2 ruling back in 2020. What is Article 46, you might ask? Well, the title of it is the transfer of data is subject to appropriate safeguards. And so kind of what some of that means is it's centered around, in the absence of a controller processor can transfer personal data to their country or an international organization. If there's appropriate safeguards in place at that organization, they're going to be transferring to enforce data subject rights, effective legal remedies for data subjects. For those of y'all that are legal nerds, you'll know if you look into GDPR and then look into every single regulation in the United States, it's very convoluted and ultimately doesn't compare apples to apples necessarily. There's some gaps in there regarding data subject rights in the United States versus what's in Europe. So some of the, you need to kind of dig a little bit more into it to know, but a legally binding enforceable instrument between public authorities and bodies is kind of one of the main areas that GDPR relies on when transferring information, and that just doesn't necessarily exist currently in the United States. There's been some efforts at the federal level. There's been many efforts at the state level. We talked about them already. But some efforts at the federal level that just haven't quite lived up to what is needed. And so, according to Schrems 2, as we just mentioned, U.S. law doesn't apply adequate protections to align with GDPR standard contractual clauses. The DPC decided that Meta's self-imposed protection measures and clauses didn't compensate for the lack of protection afforded by U.S. laws, and thus ordered Meta to cease all transfers of PI, that's personal information, to the US and any storage within 6 months of data already transferred to the US. Meta has announced it will appeal the ruling and seek suspension of the orders of court. No surprise, because that's quite a big fine and other penalties were levied against it as well. Transitioning to what's been going on in the month of May at the FTC, talk about busy over there. I'll briefly go through, there's about 6 of them I want to touch on just in the month of May that involve data privacy and consumer privacy. So Easy Healthcare Corporation is the first one. So May 17, 2023 is kind of the last update on this one. A civil settlement penalty of about 100 grand was reached between FTC and Easy Health. This company develops a fertility app called Premom. And their allegations it was sharing personal information without user consent, nor did it notify users of that sharing with, both domestic and non-domestic entities alike. And so this app's used by thousands of women. The exact number wasn't specified as to how many people were impacted, that at least I could find. But we know $100,000 is approximately the settlement, so not huge, but probably enough to where the company should implement appropriate privacy controls. The next one is Facebook, updated May 22nd. They issued a clarifying order regarding the 2021 order to the defendant, 2012 order to the defendant. So they alleged Facebook violated its privacy promises to consumers and a 2012 commission order. So they updated that order and provide some clarity. And now the plaintiff has until August 1st to respond of this year. Edmodo, it last updated May 22nd, 2023. The provider, Edmodo, collected PI from children without parental consent and used the data for advertising, violating COPA and also unlawfully outsourced COPA compliance obligations to schools. Just because you make schools do it doesn't mean you don't have to do it either. Shame on them. This is actually the first in several COPA-related arguments that the FTC is looking into, which makes that interesting. Companies starting to target children because they're just easier to click the yes button on when it's opting into sales and not thinking twice about how it's going to affect or parents needing to be involved. But we'll move on. Ring LLC, Amazon company. May 31st, 2023 was the last update here. So FTC is going to require Amazon to overhaul its deletion practices and implement stringent privacy safeguards to settle charges brought by, you guessed it, COPA, enforcement, and deceive parents and users of the Alexa voice assistant services about data deletion practices. So we'll stay tuned to see kind of what happens from there. Each of these cases is pending, by the way. I know I talked about the settlement penalty, but it's technically not been closed yet because it just hadn't been finalized regarding Easy Healthcare. But Ring pending, Amazon Alexa pending as well. The last one, so this is last updated June 5th, 2023, Microsoft Corporation. They have been charged $20 million to settle FTC charges it violated, no surprise, COPA, by collecting children's personal data who signed up for Xbox without getting parental consent or notifying parents. They also illegally retain children's personal data. I can tell you myself, I mean, I'm sure Sony is probably going to have similar charges brought to them in the past. If not, they will soon. When playing video games back when I was young, however many years ago that was, in high school and middle school, when my friends or myself would sign up for Xbox Live or, PlayStation 3, PlayStation Live, whatever it was called, there definitely was no parental control consent in place. There might have been a notice. I can't remember it now, but creating a Microsoft account and then getting on Xbox Live, providing your age, if that was something they even asked for. I'm sure they did, because I know that most of us always put that we were older than we were so we could access content and get on live without any restrictions. Obviously any reasonable individual would think, well, most kids would just circumvent that by lying about their age on there. So, obviously shame on Microsoft for doing that, but it's also very difficult to implement privacy controls around that stuff when the parents are kind of leaving the kids to do their own thing, and the kids are going to do their own thing. That wraps it up for kind of the legal updates. I wanted to really talk a little bit about Meta, and they have a responsibility. And obviously with the fines they've been hit with over the last several years, they haven't gotten that responsibility hammered out and are still just having a difficult time with GDPR, as we can tell, paying $2.5 billion. You'd think you'd have to allegedly paying $2.5 billion. They're still fighting out stuff in court, and probably will for a while so they can avoid payment. But we're going to see more stuff like that in the future. I'll go into it a little bit more maybe in my 2023 predictions, but this is just kind of the start, and Meta's been the target of a lot of data protection authority penalties because they've just been easiest to make an example of. Meta's been experimenting with some great things, some things better than others, I think, and it's just been difficult for them to comply with GDPR. I mean, I don't blame them. It's a very complicated regulation, especially for a company as large as Meta that essentially doesn't store data in one place. I mean, it's decentralized kind of by nature. Back when Zuckerberg went in front of Congress, he kind of explained that to him. But it's just very difficult for a company like that in order to rein in a lot of different areas that they're trying to comply with GDPR while still also building a business and innovating. And so we'll kind of see what ends up happening over time. It'll be interesting. I know that I mentioned Amazon was the second largest all time. They may get hammered with something soon. There's always, the big tech has been a very easy target for the DPA to kind of make examples for complying with this law. Hey, we're serious about you complying. We need you to do what we ask, or else the fines are just going to get worse and worse and worse as we go on. So we may see increased fines, but we'll kind of see how stuff plays out. Interested to follow some of these other court cases that the FTC is looking into and see what goes on from there. So this last section, let's talk a little bit about predictions for the rest of the year. So this is a no-brainer, especially if you have a head on your shoulders and are living, breathing, warm-bodied. But we're just going to continue seeing AI regulation backing and just a lot more conversations around that area. We kind of talked a little bit about it earlier. Some examples of why recently the Ontario Information Protection Agency calls for AI rules. Netherlands Data Protection Authority seeks info on how ChatGPT is learning from user inquiries. Connecticut's governor recently signed an AI bill. So unless privacy controls are programmed into the algorithm, this is where it kind of gets pretty interesting. Orgs take that privacy by design approach. An AI won't recognize, country lines. It's going to be very much kind of a global force. It's not really going to be so much of a, hey, let me check in with the current authority for this country and see if it's okay if I transfer this data. Now that possibly we could program something like that in to where a request gets submitted by the AI, and then once it receives approval or denial, it acts where it needs to go next. I think that's something that we'll see in the future in some capacity. But these risks around human extinction. There's an op-ed published about this, highlights that this thought about AI taking jobs, eventually eliminating human race, Terminator type of stuff, it distracts from risks that are more current. For example, location data gathering by an artificial intelligence sort of plug-in based tool without necessarily considering, do I need to get confirmation from the individual or consent before collecting that information? What's right and what's wrong? And right and wrong, in my opinion, are a little more objective than people would think, but most folks think those very subjective terms, a lot of based on the context of the situation. Now, granted, it is based on the context of the situation. We actually talked about this in a previous episode, context of processing. So it's probably not relevant to know if someone has a sexually transmitted disease if they're applying for an accounting position. However, someone applying for the position of, I don't know, a porn star, you probably want to know if they've had any STDs in their past life. This would be kind of a context of data collection, sort of context of authority, not necessarily authority, sorry, context of interrogation sort of approach where context matters. And so in that instance, it is wrong to ask an aspiring accountant what their sexual disease history is, but it's right to ask an aspiring porn star what their history of sexually transmitted diseases is, just for the sake of protecting those folks they may interact with. Versus the accountant, it's no one's business because it doesn't pertain to them performing their regular roles and responsibilities for the job they're applying for. It doesn't match. Another area that is, we've seen a lot of companies issue these kind of, my org included, about things to be considering when using AI responsibly. And what do you put into the algorithm? Most of us do not know where that information goes after it's shared, whether you're using ChatGPT or one of the other GPTs, or any other AI models out there. Most of us don't know where that information is going. And if you don't know where that information is going, you probably need to think twice before you input some personal information into a tool like that. Another area to look into, U.S. privacy laws are federal level beginning to lag even more as states kind of take matters into their own hands and act more proactively. So we have several bills, we talked about them already, that have been signed into law this year. Texas is kind of the one that's going to become the next one, House Bill 4. Delaware, New Hampshire next in line, and then we start to go down and see what's in committee right now. So Maine, Massachusetts, Rhode Island, and several others have quite a few bills in the pipeline. We'll see if those end up making their way through or not. But the group of states with privacy laws is starting to shrink, and we just need to think about how are we going to be able to comply with those laws or prepare for those laws once they come into play, both as consumers and as organizations operating in those states. The last one, kind of big prediction, I guess, for 2023, we've already started to see it happening, but privacy enhancing technologies. And we talked a little bit about these in some previous episodes. We'll go into more depth as the series continues, but these will continue to become big business. Consulting firms, niche product organizations, and other companies needed to implement these areas and deciding how best to, I mean, this did not exactly easy in concept, but very difficult to actually do it in some cases. But some of those being, I guess we'll go through a few examples of these. So multi-party computing. This area right here, especially secure multi-party computing, is just kind of a class of algorithms that allows a program to run on different computers to participate in a computation without compromising each party's private data. Kind of honest but curious mode, if you will. An example of this is, let's say you go on Glassdoor, for instance, and it wants you to share salary information. You can do that for the role you're at, maybe even the organization you're at too, if they get that specific. But you don't have to share any personal name, email, all that kind of stuff. So you can still participate in the processing, but you just don't have to share any information. They're collecting data, but they're not like all these companies needing our first, last name, email address just so we can download a white paper. Talk about frustrating sometimes, but that's just kind of the way that one works. Another one is homomorphic encryption. So this one is interesting. I mean, I've heard of some chatter starting to come through about it. I think some organizations are starting to have some success, or at least looking into it. But you encrypt data, and then in order to manipulate that data, use the data, it doesn't become unencrypted. So you don't need to access a database in its entirety in order to use that encrypted information. 2009 was kind of when this concept was first developed, and it's just continued to improve as technology and knowledge kind of grow as well. So you're running analysis on encrypted data without actually decrypting it. And this may be a little more prevalent than some folks might think. Could be simple. You run a SQL query to return data in order to maybe make a determination. So you need to pull in some data, run some calculations, get an answer. You don't actually have to see what's going on in that, what data that query is pulling in order to be protected. It's differential privacy, kind of moving on a little bit. Another one. So this is kind of where you inject noise into a data set, and it's a statistical method, kind of allows answers to queries about data sets while still preserving the privacy of those records. So similar to homomorphic encryption, but it just takes a little bit of a different approach. Some of these others, we'll actually talk about these in the next learning series about identity and anonymity, but this goes into the concepts that some of y'all probably are familiar with regarding k-anonymity, L-diversity, and t-closeness. And these are all very interesting concepts when you start to apply them to data sets. So k-anonymity requires that every record in the micro data must be a part of at least K records having identical quasi-identifiers. So if we were to look at a data set with age, address, and occupation, the only two anonymity, age and address being the same for each one of them. Age can be 18 to 22, and then 23 to 26, and then addresses all could have the other unique identifier in there. And we'll talk more about this later. I don't want to get into a ton of it right now and explain it, but the next one being L diversity, it enhances k-anonymity, and so it requires that there are L distinct values in each group of K records. So think of this as like a drop-down box. You have only three items to choose from, so it kind of eliminates you putting in too much information, and it just gets exactly what's needed. The last one being t-closeness. So this ensures the distribution of values in a group of K records is sufficiently close to overall distribution. So let's say we have 10 sets of 3-year age ranges, all ranging from 10 to 30, so 10 to 13, 14 to 17, 18 to 21, so on. The distribution for each of those sets of 3 is the same as the distribution of the overall age range of 10 to 30. The next one being polymorphic encryption. So this one where data is encrypted in multiple forms with multiple keys with specific functions for the data associated with each encryption set. So each key has a specific function for the encrypted data. These last couple, so this is actually part of the CIPT we'll talk about as we kind of go through the series, but there's process level and there's technical level measures to ensure data is protected. So there's 4 kind of generally, this isn't a be all end all of how it is. This is just kind of general concepts and how you can apply them. So we have a measure of demonstrate. So we're cover the process side real quick. Demonstrating, auditing, recording, reporting. You're doing what you say you're doing. Enforcing, you are creating policies, you are upholding those policies, you're maintaining those policies, continuously improving upon them. The next one being informing, you notify, you supply, and you explain what's going on with data collection, data processing. What we kind of see in a lot of those privacy laws. The last process level one being control. So you allow consent, you allow users to choose, update their information, and retract. So this just mainly centers around allowing users to have control over their information and what's done with it. These other 4 are technical measures. And so these, those are very much process level, policy based. We can create privacy notices. These other ones are kind of technical in how they get applied. So these would be a lot more on the programming side, developer side, not as much the policy side of things. So the first one, we can abstract that information. In other words, we can perturb that information, inject noise, we can group it, we can summarize the information, just make it in a way that it's not, easily readable by someone else. We can minimize the interactions, excluding, selecting, stripping, and destroying. Essentially, you are minimizing the opportunities for someone to interact with information. The next technical measure would be separating. So we're either doing this logically or we're doing this physically. We're distributing physically, separating data into different physical locations, or we're isolating it into different logical locations. The last one being hiding. And so this one is more, this one kind of encryption comes into play a little bit. Obfuscating, restricting access, disassociating records from each other, mixing random information in there just to kind of throw someone off, protect the identity of somebody. And we'll talk about those more as we go into later podcast episodes. But the last PET area would just be implementing frameworks in your organization. So some good ones that I've used in the past. NIST privacy framework is great. Using GAPP principles as well is an effective tool. HIPAA security has an appendix in there that kind of explains what are the requirements, what are the addressable measures. ISO has various certifications around information privacy and risk management related to privacy. FTC has privacy principles as well that can be employed are implemented, and the OECD also has some privacy principles, looking at data quality and some of the other areas as well. So that'll do it for today's install of the Data Privacy Party podcast. Thanks you guys for tuning in. Sorry again that this came a little bit late, but glad to kind of cover some of the big things of 2023 and looking forward what we're going to be seeing as we go through. Some concluding thoughts I have is keep an eye on legal landscape. New state privacy laws are coming. If you live in a state that has those laws, Texas for me, for example, we can look at 2024, 2025 as some kind of interesting time periods. There's just going to be more and more going on related to privacy until something else takes over. Several European data laws are coming through the pipeline. I won't mention what they are in detail, but I know Data Act, Data Governance Act, and some others are coming through. Had the privilege of sitting in on an IAPP event the other night that did a great job of explaining what some of those things are and what they cover. Figure out what data you have, think about who has it, email subscriptions, online purchases, where do you go when you often surf the web. That sort of information gets put out there, and I advise you just understand what you're giving up and what are you getting in return. Check out the website for more information. As I said, I think earlier, I'm working on a PET post to kind of help understand what privacy enhancing technologies are and how you can kind of use them. And then see older episodes as well. We have our introduction to privacy series going on. I recently passed the exam related to that book. So hopefully it's a good resource you use as you get yourself ready, not just to learn more about privacy, but maybe even when you study for the CIPT exam as well. But thanks you guys for tuning in today, and I will talk to y'all later.